As expected, Brenay has filed a motion to stay enforcement of her judgment in the amount of $1.75 million. We're going to break down what this filing actually says, what her legal counsel is asking of the court, and what we can reasonably expect to happen next. My usual disclaimer applies here. Certified law nerd, bona fide non-attorney. This is not legal advice. Let's begin. This motion is about pausing collection activity while the appeal moves forward. I've covered this in multiple videos now, and from the beginning when I explained the collections process, I said we should expect to see this filing if the case ever reached the appellate stage. But that pause does not happen automatically. It only happens through a court-approved process. In this motion, the defense walks the court through a very clean procedural timeline. First, that a jury verdict was entered. Second, that a Rule 59 motion for a new trial was filed and later denied. Third, that a notice of appeal was timely filed. And finally, that the appellate paperwork, including the transcript order, has already been submitted. That sequence matters because a stay of execution is only available once an appeal is properly underway. So this filing is signaling to the court that every procedural box has been checked. Now, this motion relies on Rule 62 and NC General Statute 1-289. I'll put that up in just a sec. They govern how money judgments are handled during an appeal. Under that framework, enforcement can be paused only if the defendant provides a court-approved undertaking, also known as a surety or bond. That is why the motion is structured the way that it is. The defense is not asking the court to guess at a number, and they're not asking the court to waive any requirements. They are asking the judge to do three very specific things. First, to set a hearing. Next, to determine the amount of the undertaking or the bond. Then, pause enforcement once that undertaking is actually posted. That sequencing is intentional. And to be precise here, the stay becomes available once the appeal is taken, but it only becomes effective after the court approves the bond. I forgot to mention, the motion also includes language about irreparable harm if property is seized or sold before appellate review. That language serves one purpose. It is boilerplate, but it is intentional. That is urgency. It's telling the court this issue is time-sensitive and supports the need for a prompt hearing. It does not replace the statutory requirement for a bond. It's just explaining why the court should act quickly to determine the amount. Now, at the hearing, the judge's role will be very specific. The court will determine the amount required to secure the judgment during appeal, the form that security must take, and whether the proposed undertaking adequately protects the judgment creditor, Akira. Now, when we talk about the form of security, we're talking about more than just a dollar figure. The judge is deciding how that money is being guaranteed. That includes whether the bond is issued by an acceptable surety, whether collateral is required, and whether the court finds the security enforceable and reliable. And it's important to remember why this bond exists in the first place. The bond is not there to protect the defendant. It is there to protect the judgment creditor, Akira. The purpose of the bond is to ensure that if the appeal fails, the judgment creditor does not lose time, leverage, or collectability because enforcement was paused. In other words, the stay is a privilege. The bond is the price of that privilege. Once the court sets the amount and approves the form, enforcement only pauses after the defendant actually posts the bond. Now, an undertaking is usually obtained through a surety company, similar in structure to how bail bonds work, but the underwriting here is far more rigorous. The defendant applies with a surety provider, and that surety conducts a full financial risk assessment. They will evaluate creditworthiness, liquidity, assets, existing judgments, and pending litigation that could affect the defendant's ability to reimburse the bond if it is called. That last part matters. A surety is guaranteeing payment of the judgment up front if the appeal fails. In other words, they are guaranteeing payment to Akira if Brenay's appeal fails. They are not waiting to see if Brenay can pay later. If the bond is called, the surety pays first and then seeks reimbursement. Because of that, they take pending legal exposure seriously. In Brenay's case, that includes unresolved matters like pending cyberstalking charges that could affect her livelihood and an upcoming trial involving alimony and equitable distribution. Those proceedings are relevant to a surety not because of the allegations themselves, but because they can impact future finances, asset division, and overall ability to repay a seven-figure obligation. In short, a surety company's concern is simple. If the appeal fails, can this person make us whole? Approval is not automatic. This is a financial underwriting decision, and even if a surety is willing to issue a bond, the court must still accept the form of security offered. Now, I want to take a second to address something I've been getting in my DMs regularly. This question seems to be popping up, and I'm not sure why, but I keep being asked whether this judgment is set in stone or whether anything is final because the appeal is pending. For the record, this judgment has been entered. It is final, it exists, and it is enforceable. An appeal does not mean the judgment disappears or that the judgment is hanging in the balance. It does not mean the verdict is provisional. It means the judgment stands unless and until an appellate court says otherwise. If there were an error warranting an automatic reversal or a new trial, that would typically surface at the Rule 59 stage. We did not see that happen. That motion was denied. The arguments raised in the Rule 59 motion and the issues identified in the appellate transcript documentation do not point to an automatic reversal. An appeal is not a redo, people. It is a narrow review of alleged legal error. So while appeals are a normal part of the process and outcomes are never guaranteed, the notion that this judgment is somehow not real or not settled is a little misleading. Akira won a judgment. That judgment is entered. The appeal challenges it, but it does not erase it. So what should we expect next? Given the argument about irreparable harm and the fact that collection activity has begun, we should see a hearing set relatively quickly. That hearing will not revisit the verdict, and it does not argue the merits of the appeal that is down the road. Its sole focus is to determine how the judgment is to be secured during the appellate process. Once the court rules on an amount and the form of undertaking, the next step is going to depend on whether a security is posted. If the bond is approved and posted, then the stay is commonly granted. But if for any reason the bond cannot be approved or the proposed security does not adequately protect the creditor, who is Akira, then enforcement will continue. This filing is not unusual. This is standard appellant procedure. Yes, the process is costly. Yes, the bond for this judgment is going to be pricey, but this is the price of having to protect the appellant during the appeals process. Otherwise, they are left exposed. And so this is a privilege for the appellant and protection for the creditor. Now we wait again, watch the docket, and let the process play out. I'll catch you in the next one.